Okay, so we seem to be all set. Quick change. This is just a summary of service and assistance animals, and as I mentioned in the beginning, part of the reason this is somewhat topical is that a law passed this year, and I included the purpose of the law at the very beginning of my materials, which is fairly self-evident. How many people have been subject to a Hawaii Civil Rights Commission investigation to do with animals? So a few of you, so you will know that is not always a lot of fun. This is I don't want to say a dangerous area, but there's a lot of potential liability if you don't handle these requests for animals correctly. You can get into trouble, and unfortunately it's not as clear as you might think, simply because, in particular, the Hawaii Civil Rights Commission reaches interpretations which aren't necessarily even written in the law, but will cause you a lot of trouble if you don't follow them. So your first question in deciding whether you can prohibit animals is, if you're in a condominium, most people agree, and it's been this way for 25 plus years, you can only prohibit animals from your building if the prohibition is in your bylaws or maybe your declaration. This is part of a senator of maybe 25, 30 years ago. He was insistent on this, and the law was changed to say, if you're in a condominium, you can't prohibit people from having animals, although you can certainly control animals, but you have to amend your bylaws to say no animals. If you're not in a condominium, there are some other issues, but the general rule judges seem to follow is, if you're going to prohibit someone's use of their unit, for example, having a dog in their unit, that should be in one of the documents that the owners have to approve, not just the board approves. So house rules are usually not the best place to prohibit animals. The second point is, even if you did amend your bylaws to prohibit animals, if the person needs the animal because of a disability, your prohibition is usually meaningless anyway. And that's because of the Americans with Disabilities Act or the federal and state fair housing laws, which I mentioned at the bottom of the first page of my materials. And basically they say you cannot prevent people with disabilities from having animals. Now you may wonder, what is the difference between the Americans with Disabilities Act and the Fair Housing laws? The main difference is that it applies to different situations. The ADA applies to commercial type property, which can include hotel type uses, so it can be in effect in a residential building. The fair housing laws apply purely to residential buildings. The ADA does not apply to a purely residential building. And I included an excerpt from a technical assistance manual which explains the difference. So, for example, if your rec room or swimming pool area is only available to residents and their guests, that is considered residential. If you have the public coming into your facility, that's considered commercial, and that would be subject to the ADA. So, and I would just point out, a lot of the materials in my handout you may think is John Morris crazy, writing all this crazy stuff down. In fact, a lot of it's just excerpted straight out of the position papers that you get from the federal government or the state government as to how they interpret the law. So even though I don't necessarily disagree with what it says, in many cases it's just taken straight out of what they're telling you, and that's why you may think, is John Morris crazy for putting all this stuff in? It is not me, it's what the people are saying. And I point out at the bottom of the page 2, you can be in a residential and commercial building at the same time. If you allow short-term rentals in your building, it would be considered a place of lodging, and usually that's 30 days or less. The ADA could apply, and I've mentioned the Mabson case from about 10 years ago. That was a building which allowed hotel rental of units, certain areas, and long-term residential in others. So the judge basically said the ADA applies where there's short-term rentals and the Fair Housing Acts apply where there are long-term rentals. So what is the difference? Usually when you're talking about the ADA, the commercial law, you're talking about a service animal. So this is supposedly an animal that has been specially trained to provide a service. And it excludes the provision of emotional support, well-being, comfort, or companionship. That does not qualify an animal as a service animal. It has to be trained to do specific tasks for the disabled person. So again, this is the law that applies when you're going into a commercial facility, a restaurant, a hotel, any type of store. So that's when you'll be worrying about what is a service animal. Then what is an assistance animal? I like to use that term for residential properties, but some people call them comfort animals, emotional support animals. So it is two different things. And I prefer, if you use service animal when you're talking about a residential, I find that a bit confusing. So that's one of the things you should try to keep straight. In theory, an assistance animal is not a pet. So they're not just there to make people feel good, but unfortunately, when they define an assistance animal, it could easily be a pet. It's just they say it's not, but in fact it really is. And the difference you should notice, basically, a service animal is supposed to be a dog. Not other types of animal, except for some incredible reason, a miniature horse. Why the hell that's possible, I do not know, but it, to me, undermines the effectiveness of this law, because your service animal has to be a dog or it has to be a miniature horse. I don't even know what the definition of a miniature horse is. What if somebody shows up with a pony and it's like big enough to ride? I really don't know, but that to me undermines the whole credibility of the ADA, is the fact that it can be a miniature horse or a dog. When it comes to an assistance animal, to the animal that you can bring into a residential property, it's pretty much any animal that's legal to have in the state of Hawaii. There is a Hawaii case about a pig that was considered to be an assistance animal, an animal that someone required for emotional support, for comfort. But almost any animal can be an assistance animal as long as it's legal to have in the state of Hawaii. And the main thing to remember is assistance animals have to have no training. Service animals are supposed to have training. Then we go over to how do you determine whether someone has an assistance animal or a service animal? Top of page 4, what questions can you ask? And I've highlighted them in bold. When somebody shows up at your store or your hotel-type condominium with a dog or a miniature horse, you're allowed to ask 2 questions. Is this a service animal that is required because of a disability? And what work or tasks has the animal been trained to perform? Now, you would think that because it's supposed to be trained, you should say, can you provide me with a little certificate showing that this animal has been trained? And the answer, as in most cases in dealing with these laws, is, can you ask for that? The answer is no, you can't. You can only really ask those 2 questions. And that's, to me, is one of the other problems. What is the point of saying this animal has to be trained when there's no obligation to provide any proof of the training? They can just show up and tell you. And again, the task it's been trained to perform just to make me feel good about eating lunch is probably enough. I wouldn't want to tell you to exclude that animal. And you have to be careful. What the government doesn't like you to do is you not only can't request documentation, you can't say, please demonstrate to me what your dog has been trained to perform. You're not allowed to do that. And you're not supposed to say, what is your disability? What is it helping you with? That is also no. So again, most of the questions you think, can I do this? The answer is almost always going to be no. Now, when you come to the point of when can you deny the animal the ability to come into your restaurant, business, or hotel, it has to be out of control and the handler doesn't do anything to control it. It's not housebroken, so it comes in and poops and pees all over your carpet. Then you could say leave, but then there's supposed to be an exception if it has an illness or some problem. So the guy says, oh, I'm sorry, my dog's not feeling well today. That's why it pooped on your carpet. That's not necessarily a reason for barring it. Again, if you get in this situation, be very cautious because a lot of these things don't seem to make sense. If it creates a direct threat to the health or safety of others. If the dog comes in and lunges at you and tries to bite you, that may be grounds to keep the dog out. You would hope so, but again, not necessarily clear. And if you read this page 4, you will see that all the things you think would be fairly straightforward. You can't say, oh, I don't allow pit bulls into my area because they're dangerous dogs. That's not going to work. So again, that's part of the problem. The only little bit of sanity that I find, bottom of page 4, is if you have a pool area, you may have to allow, say you're a condo that allows short-term rentals, you may have to allow the dog into your pool area, but you don't have to allow it in the swimming pool. Thank God. You would think the way things are, that's one of the few little black lines that you might find is you don't have to allow it into the pool. Anyway, just a little. So again, keep in mind we're talking about service animals, and I am only dealing with the ones, again, if you're commercial, hotel, business, restaurant. Then we turn over page 5. What can you ask about an assistance animal? This is what's called a reasonable accommodation. You are allowing the animal under the state and federal fair housing laws to reasonably accommodate the disability of the resident who needs that. So now again, you can ask some questions here, but if the need for the animal is readily apparent, and in fact that's true with service dogs too. If somebody comes in and they have a dog on a short leash and they're wearing dark glasses with a white cane, you can't say, what is your disability? Please provide some evidence of why you need this animal. It's because it's obvious. You're not really allowed to grill people over what's obvious. If the animal is pulling them in a wheelchair, it's pretty obvious that's why they have the animal. But that's one of the problems you have. So as far as the questions you can ask about why does this person need their assistance animal, their emotional support animal? If the disability is not obvious, this is the middle of page 5, you can verify that the person is disabled, i.e. they meet the definition of disability under the fair housing laws. That is a physical or mental impairment that substantially limits one or more major life activities. And then, so this is the first issue. The second is they have to tell you the needed accommodation, which of course in this case is a dog or other animal, and then they're supposed to tell you the relationship between why they need the dog and the accommodation. The problem you run into is the Hawaii Civil Rights Commission says you can't ask them what their disability is. So in a lot of ways this is pretty meaningless. So if someone shows up at your residential building and says, I need to have this dog or this cat, you can ask them to provide some kind of proof. Unlike the service animal in a commercial building, you can ask for some kind of proof. Usually you can ask for a doctor or some qualified person to say, in my opinion, this person is disabled within the meaning of the law. So you can ask for that in writing, and then you can ask that person to describe why their patient or other person needs the dog, and the relationship between the dog and the disability. So you can ask these questions for an assistance, emotional support, comfort animal. But it doesn't really do you much good, because if you inquire too much, then you're deemed to be asking for too much information. You can't say, what is your disability? What is the animal doing for you? And the other problem is, it doesn't have to be a doctor. You don't have the right to ask for this information from a doctor. It can be a peer support group. Say somebody runs a peer support group, they can provide you with the information that this person needs their assistance animal. Doesn't have to be a medical person, it's just a so-called reliable third party. But the thing to remember is, if they come in with this information, you are almost always going to be unable to prevent that person from having in your residential building that assistance animal. It's one of those, they stole it fair and square. There is not a lot you can do about it. You're stuck. So again, if someone comes in with a piece of paper from a doctor who says this person is disabled and they need a dog because of their disability, that's pretty much all you can require. There are a lot of cases where the board tries to do more, and then the Hawaii Civil Rights Commission shows up, or the animal owner gets an attorney, and then there's going to be a little lawsuit and negotiation, and your insurance company will pay out money. So the main thing you should remember is, and the other thing is to try to have a standardized procedure. If you ask one person one set of questions and another person another set, that can be considered discrimination. That happened to me once. The board had handled these processes for a while. Someone came in, they turned it over to me, I did my standard process. Because it wasn't identical to what the board had been doing before, that was deemed to be discrimination by the Hawaii Civil Rights Commission. It took them about 6 months, and finally they realized there wasn't much they could say because I was following the law and doing what I was doing. But that's another thing to worry about. Controlling service animals. Again, these are the animals when you're in a commercial hotel, store, restaurant. There are certain things you can make them do, but you can't necessarily force the owner of a service animal to have that animal on a leash. I've got a case right now where the man claims the animal has to be free to go ahead of him because he has PTSD and he needs to be sure that his animal is checking out for unpleasant people who may be awaiting him. So you can see at the bottom of page 6, controlling. What can you do? Now, if you're in a residential building, again, that is not going to apply to you, but if you're in any type of commercial hotel type condominium, if you have a convenience store or a restaurant, you could run into this problem. Top of page 7, common questions about restricting service animals. Again, this is under the ADA. They don't need a vest. A lot of people like to stick a vest on their service animal. It talks about handler is responsible. The guest must provide you must have the same sort of service for everybody. You can't restrict people with service animals to certain rooms in your property. And then there's things about charging for cleaning. You can have more than one service animal. Sometimes they have one for one purpose, sometimes for another. Anyway, those are the issues you have to think about. Again, not going to apply to you necessarily in a residential building. And then the second little bit, controlling assistance animals. I've provided you with an excerpt straight out of the Hawaii Civil Rights Commission rules, giving you some examples of how they see your ability to control an assistance animal. This could be a dog, cat, miniature pig, anything like that. That could be an assistance animal. Again, any animal that is not illegal to have in Hawaii. And this is, you can read their rule. It gives you exactly what circumstances you can take action to control that animal, that assistance, emotional support. If you read through, and they give you a little example there, which will give you some idea. Bottom of page 8. common questions about restricting assistance animals. The Hawaii Civil Rights Commission says all of these things are okay. Having the animal licensed, if a license is needed, having the animal documented with documentation of the vaccinated with documentation of the vaccination, requiring that the animal be registered. You can check it in, take a little photograph, make them fill out a form. Have it meet minimum sanitary standards, require the owner of the assistance animal to pick up solid waste, have the animal under the control of its handler, on a leash, in a cage, something like that. But that is only if the animal has to be on a leash. If there's some reason it doesn't have to be, it's supposed to be under the control of the handler by voice signals or other means. Probably not going to happen, but that's something you should keep in mind. You can't require a little old lady with a pit bull to carry her animal through the common elements. That's not going to work very well. The Civil Rights Commission will not like that. You have to be realistic. You can't say every animal has to be in a cage. A 60-pound dog in a cage is going to be pretty hard to lump around. Having the person assume responsibility for damages, that's good, that should be pretty good, but you can't require deposits, fees, surcharges, or liability insurance. You may be able to require liability insurance if the association requires everyone in the building to have liability insurance, which you should, but which generally requires a vote of a majority of the owners. And then you can have the person clean up the unit by fumigation, whatever is needed to make it clean. So those are the basic parameters you're operating under. When you have an assistance animal, most of you, if you're in a residential building, you can kind of forget about the service animal issues, but you do have to be aware of assistance animal. And finally, I have just given you a brief summary of Act 217, which again was passed this year, to supposedly control the use of false service animals. You'll note that the governor didn't even sign this. He didn't want to be associated with it. He gave reasons why not. The problem is this was pushed by a specific senator who actually owned a store on the Big Island, but there's no government agency will enforce it, and it's very difficult to enforce because you're only allowed to ask those two questions. And again, this does not relate to assistance animals. This is only service animals. So if you're in a residential condominium, it does not help you at all. If you are a business, a hotel-type condo, it could. I actually have kept a case. It's a California case in which the court ruled that this false service animal was in fact a false service animal. A woman went to a theme park one day with her dog, wanted to take it in. They said no. She came back the next day with a vest and a little thing. She got off the internet and said, now it's a service animal. They still said no. She took them to court, and the judge ruled that the animal was not a service animal, that she had just concocted a story. So I keep that case just to make myself feel good to know that it is possible that there are restrictions, because again, in this area, whether it's an assistance animal or a service animal, you should start from the mindset, there's absolutely nothing I can do about this to prevent this animal from coming in. The only thing I can do is try to make the owner of the animal control it, keep it in from bothering other people, from howling all day long, those types of things. But just to give you an idea, a couple of things. The Hawaii Civil Rights Commission says even though a resident of a building can be required to provide information about their need for their assistance animal, if their friend shows up and as a visitor with an assistance animal, you can't do anything. You can't ask for any of that information. So that means the person who lives in the building has to provide you with more information than the person who just shows up to visit. So that to me is symptomatic of how this comes about. But the main thing to remember is there's almost nothing you can do about it except try and make the person control. Now, even if, for example, the animal lunges at someone and tries to bite them, or even does bite them, that may not be grounds to throw that dog out of the property. Instead, you may have to say, get a muzzle, and put that muzzle on your dog at all times when it's on the common elements. That is the sort of thing the Hawaii Civil Rights Commission may say to you. If you say this animal is dangerous, it has to go, they may say, no, it does not. Put a muzzle on it. It won't be able to bite you. It may knock you down and do all these other things, but that's okay, apparently. Anyway, so that's a brief and disillusioning summary of assistance and service animals for you. And again, the main thing is there is not a lot you can do except to make them toe the line once they move in. So I think now we have time for questions. I don't know if any of you took my advice and filled out the little yellow forms. If you have, you can...